Your Honor, it's
Let's
Robert
go on the
Miller.
record on cause number DC 1918220, Zubarek versus Gonzalez. Counsel, make your appearances.
Robert Miller here on behalf of Mr. Zubarek.
Brent Bisey on behalf of the Valley View Parks Estates Homeowners Association.
Greg Fell for Francisco and Marianne Gonzalez.
Caitlin Koger for the First Amended Phillips Family Trust, Eric Sorensen, Jamie Sorensen, David Smeltzer, and Lindsay Smeltzer.
Kelly Milligan for Ronnie Henderson.
Casey Myers for Valley View Park Estates.
Okay, we're here on a motion for summary judgment. Why don't we go ahead and proceed?
Thank you, Your
Thank
Honor.
you, Judge. Before we begin, the Valley View Park Estates HOA has filed a number of objections to the evidence that was attached to Mr. Zubarek's motion for summary judgment, as well as a number of objections to the affidavit that accompanied that. I believe that it would be best if we were to begin with those objections if the court would prefer.
Mr. Miller?
Their objections are not well taken, Your Honor.
We have a limited amount of time here, so it's kind of up to y'all how you want to do it. I have another hearing in about 20 minutes, or actually, Mr. Hayes, is Mr. Hayes on the phone? I don't know if he is, or Mr. Palter.
Yes, Your Honor, I'm on the phone.
Do y'all still need your hearing, or is it, are we going to pass it?
We do need our hearing, Your Honor.
Okay. All right, so I'd say we have about 10 minutes total. So I'll just give 5 minutes to Mr. Miller and then 5 minutes to the other side, and we'll just kind of figure it out. And you can use that 5 minutes however you like. So
Understood, Judge. Thank you.
Mr. Miller, you may proceed. Ms. Dean, if you could go ahead and keep time for us.
Thank you, Your Honor. Mr. Zubarek, this case is that he violated Article 12, Section 9 of the Declaration, matters of dispute or disagreement between the owners with respect to interpretation of the application. They've objected to his affidavit, even though his affidavit, he says that I am attaching the email he sent to the HOA before this lawsuit was filed. And his affidavit is clearly, he understands that email. It was his email. He sent it to him before he filed this lawsuit. And without agreeing that he had to go to the board, as there was no disagreement that the fences violated the declaration. This court has found that those fences did violate the declaration, and the HOA cannot amend the declaration without having a vote of the owners. They can't just do it by fiat by the board of directors. There is no dispute that the fences violated the declaration, as the plain language of the declaration shows it is a violation. Mr. Zubarek submitted the email he sent to the board, which is Exhibit 1 in his affidavit. He stated it was his email to the board sent before the litigation was filed. His affidavit satisfies Rule of Evidence 901-1, as he has knowledge of the email since it was him that sent it, and the other exhibits. But this one, the one exhibit that they're really missed, this lawsuit should never have been filed. Third, the law does not require a futile act. Here, the board majority were the same people who violated the declaration. In their response that they filed, they show the HOA board doing a self-serving thing, saying that we think that it's okay to have those fences. And they have the 5 board of directors people. 3 of them are people who built the fences. There's the Smeltzers and the Sorensens, Miss Dunn, who is the wife of Henderson, and Phillips are the same people who built the fences. And he was supposed to go back to them and explain to them why they were doing it wrong. He did it anyway, and they just didn't respond to him. And evidently they don't care too much about your decision either, but they haven't brought forth any evidence that would raise a fact issue other than the self-serving decision by the board. 3 of them, who I've just said, there are no fact issues on this case, and on this motion for summary judgment should be granted, Your Honor. And I reserve any time to give a quick rebuttal.
Okay, response?
Thank you, Judge. First and foremost, the basis of which opposing counsel has cited for why this email is supposedly authentic. None of these statements are present in this affidavit. These are all broad assumptions. Moreover, Judge, there's more than just a single email attached to this motion for summary judgment. There is also minutes from the HOA, a meeting of the HOA board on 2 different occasions. Those minutes are attached without any business record affidavit or authentication by the plaintiff. There's also a 4th exhibit, which is hearsay upon hearsay. It is a letter written by an attorney to the board, and that letter also cites other exhibits. Those exhibits in that letter are not attached to the motion. And the 5th and final exhibit, Judge, is a letter that opposing counsel wrote himself to the HOA board. These exhibits do not have the proper foundation. They also reference items that relate to the overall suit, not this counterclaim here. The issue before the court in this motion for summary judgment that opposing counsel has filed relates to a counterclaim that the HOA has filed against the plaintiff. That claim is for a violation of the CC&Rs. The CC&R violation, the section that was violated, Judge, is section 9, which relates to disputes. Opposing counsel accurately cites that section. However, I believe that there's a clear misinterpretation. Opposing counsel states that there is no issue, there's no difference of opinion. However, Judge, in order for there to be a declaratory judgment cause of action filed, a prerequisite is that there's a justiciable controversy or dispute in which there's a real and substantial controversy or dispute involving a genuine conflict of tangible interests. Judge, the central question is whether or not the CC&Rs permit there to be fences within easements. The plaintiff believes that there are prohibited. The defendants, as well as the HOA, believes that those types of fences are permissible. Therefore, there is a clear dispute as to the interpretation or application of the provisions of the restated declarations of the HOA. Therefore, Mr. Zubarg was required to submit this dispute first to the HOA. According to the exhibits that we have provided in our response, which are properly authenticated by a business record affidavit and which were not objected to by opposing counsel, those records show that the lawsuit clearly is a dispute of the bylaws and the CC&Rs between members of the HOA. That business record affidavit also proves the authenticity of the same document, which further states that the board unanimously agreed that the plaintiff did not bring this dispute for determination by the board. Plaintiff relies on an email, the very first email that was cited here. He relies on this email stating that this was his attempt to bring this issue before the board. However, Judge, if the court were to look at the specific words of that email, it only states various provisions of the CC&R. It does not ask the board to make a determination. And further, Judge, opposing counsel also states that to have brought this request for determination to the board as a futile act is improper before this court. Futility as a doctrine in general is most only used almost exclusively in the shareholder derivative litigation, and that must be pled at the outset of the litigation. It cannot be pled for the first time upon a summary judgment.
So the email you're talking about where he doesn't request them to do anything, is that the August 10th, 2019 email at 1:01 a.m.?
I believe so, Judge. That would be exhibit number 1.
Exhibit 1. It's hard to tell which is exhibit 1. Okay, I think that's
exhibit. It'd be page 7 of the PDF. That's where it would begin. So yes, the August 10th at 1:01 a.m. So Judge, in that email, he just simply states.
Mr. Miller, I kind of agree with him. I don't see where he asked the board to take an action here.
He's taken them to not take an action and approve any fences, Your Honor, which they just ignore.
And Judge, if that is the position, then clearly there is a dispute among the applications. So if opposing counsel is arguing that there's no dispute here, then the entirety of this case must be non-suited because clearly everyone agrees that these fences are permissible. The difference of opinion is the dispute. So there's a clearly justiciable issue here of material interest being the privacy fences along these walls here. Opposing counsel makes this argument on futility that a number of the board members have fences along this perimeter wall. However, what opposing counsel in their summary judgment motion or in their response to the petition of our counterclaim, at no point was the two elements required for futility to be met. In order for futility to be sustained by this court,
5 minutes.
the plaintiff or the person asserting futility must show.
Your time is up. Okay, I'm going to go ahead and deny the summary judgment. Did you guys submit an order as to this?
Yes, Judge. We have 3 orders that were submitted, 2 for different objections, and then we also have an order that is denying the motion for summary judgment that was submitted this morning at about, I believe, 8:15, 8:30. This
You guys have so many different summary judgments and cross summary judgments, so I want to make sure I have the right order here. Is this the order that you wanted me to sign, or is there something else? Or is this a different motion? This is what's...
That's a different motion.
That would be a different motion, Judge.
Okay. Go ahead and submit all of those orders. Email them to Rhonda. And go ahead and when you email it, go ahead and update the order, including the order that I ruled orally on March 1st, 2021, that the summary judgment was denied. This order will, put that into effect. And then also for the objections, I'm going to sustain the objections. So go ahead and include that as well in the order, but make sure that includes in the order that includes today's date. And then I heard this and orally ruled. So, and try to get that to me by the end of the day. Anything else, guys?
That's all we have, Judge. We will get that to you soon.
All right. Thank you, guys. Have a good day.
Thank you, Judge.
Anala Aviation versus Convergence Aviation. Are both sides here on that?
May we be excused, Your Honor?
You may.
Thank you.
Yes, Your Honor. John Palter on behalf of Convergence Aviation Limited and Convergence Aviation, Inc.
Mr. Hayes is in the waiting room. Let him come in. All right, Mr. Hayes, are you here for Anala Aviation?
Yes, Your Honor.
Okay. Let's go on the record on cause number DC166541, Anala Aviation versus Convergence Aviation. Counsel, make your appearances.
Good morning, Your Honor. John Palter on behalf of Convergence Aviation, Inc. and Convergence Aviation Limited.
Scott Hayes on behalf of Anala Aviation and third-party defendant Orville Yarger.
All right, we're here on a summary judgment. Go ahead and proceed.
Thank you, Your Honor. John Palter. Back on May 18th of 2016, this court granted final summary judgment on Olana's Aviation's breach of contract and declaratory judgment. Subsequently, a second lawsuit, this lawsuit was filed seeking a breach of contract claim. They were able to get a default judgment against my client, and we are here today based upon a motion for summary judgment seeking that Onala's breach of contract claim is barred by res judicata and collateral estoppel by virtue of this court's previous motion for summary judgment on May 18th, 2016. There are no disputed questions of fact because this is unique to the pleadings themselves, and that as a matter of law, because the same parties are involving the same contract, and that contract involves the same engine at issue in the original lawsuit, it arises from the same transaction or series of transactions. Therefore, the claims that the plaintiffs are now bringing were filed or alternatively should have been filed in the previous lawsuit, and therefore they are barred today. Your Honor, in support of our motion, there are two Supreme Court decisions, one Supreme Court decision directly on point. One is the Barr versus Resolution Trust Corporation. It's a 1992 Joe Morris case. Judge Morris entered summary judgment in favor of a partner, and the bank appealed. In that case, the Court of Appeals reversed, and Judge Gonzalez at the Supreme Court says that any cause of action that arises out of the same facts should have been litigated in the same lawsuit. And that in that case, res judicata barred the bank from filing a separate lawsuit seeking to hold the partner party to a lawsuit to collect after it had previously litigated liability on the notes against the partner in his capacity as the individual guarantor. And that's exactly the fact pattern we have here. Your Honor, the issue in this case is that the original lawsuit was filed seeking ownership of the engine to the aircraft. It was filed under the basis of a bill of sale. At that time, Onala only filed the lawsuit against Convergence Aviation, Inc. A third party, Convergence Aviation Limited, intervened in that case, and both of them sought a counterclaim specifically seeking liability under the purchase and sale agreement, of which the bill of sale was issued subsequently but was pursuant to that purchase and sale agreement. The court, this original lawsuit was filed back in 2015, and on April of 16, Convergence filed motion for summary judgment on their cause of action, both for a declaratory judgment and for breach of the contract itself. It's important to note that under the court's scheduling order, it was designated a level 2, and that all pleadings were to have been filed before April 13th of 2016. 7 days before the hearing on May 6, 2016, counsel for Onala filed a motion for leave to amend the complaint, and that motion was denied. Summary judgment was granted. There was no question of ambiguity. As a matter of law, the engine was not conveyed. Final summary judgment was entered in that case on May 18th, 2016, and the remainder claims asserted by my clients were dismissed. On May 31st of 2016, Onala initiated this cause of action, not in this court, but in the 44th, basically seeking a collateral attack under this court's prior May 18th final judgment. It attempted to serve under an old address. We had no knowledge of it. It obtained a default judgment for monetary damages against my clients in connection with that default judgment. Subsequently, a bill of review was filed. An agreed order granting our bill of was entered by this court on April 31st of 2020. Convergence filed its original answer, affirmative defenses, and counterclaims seeking basically res judicata and collateral estoppel. And there is a third-party claim against Orville Yarger that is not at issue in this motion.
Well, let me ask a question real quick. So in the defendant's response, they say that in the previous case, at the summary judgment hearing, counsel for Convergence entities opposed the pleading amendment and argued that such claims, the breach of contract claims, could be brought in a separate suit. Is that accurate?
No, Your Honor, it's not accurate. There was never an agreement that it could be brought in a separate suit. The motion for leave to allow them was denied, and there was no Rule 11 agreement or otherwise agreeing that they could bring this in a separate lawsuit. And furthermore, what they sought was not only a claim for the engine that was specifically covered, but also claiming that they were entitled to damages. And if, Your Honor, if that was the case, if we had agreed that they could bring it in a separate lawsuit, why not just pick up the phone and call counsel that they know were representing them and saying, by the way, we've now filed this lawsuit? They never did that. They never picked up the phone and said, by the way, we've now filed a separate lawsuit, and therefore we proceeded to default judgment. This court entered default judgment without counsel even giving the courtesy of the prior lawyer notice of that hearing.
That issue's been dealt with though, right?
That's correct. We're now here, Your Honor, and what we're seeking, the default judgment has now been vacated, but now we're back in the same claim. They're seeking claims for breach of contract, and those claims for breach of contract have been dealt with by virtue of this court's previous final judgment. And for those reasons, Your Honor, because we're dealing with the same contract between the same parties, of which there's now a previous final summary judgment.
Mr. Hayes, so I'm looking at your response here, and
Yes.
I'm not, it's possible with the way the clerks file things, I may be missing something. So I wanted to kind of ask you, it says the plaintiff's response to the defendant's traditional motion for summary judgment. Is this the correct response to this motion?
Yes.
Okay.
Yes.
And I'm looking at it, and there may be something missing, so I'm not fussing with you or anything like
Sure.
that, but I want to make sure we're on the same page. Did you not file any affidavits or anything attached to your response?
I did not. I referenced the applicable pleadings, both the lawsuits. I've included on page 3 of the response, there is paragraph 3 of the aircraft purchase and sale agreement.
Okay.
That is attached to and part of defendant's motion for.
So that's the only evidence you're really relying on, is that?
That and the pleadings that are before the court. The issue first, initially, in the initial lawsuit, counsel referenced a breach of contract claim by Anala. The claim was not a breach of contract. It was a deck action that a bill of sale conveyed title to the engine. The response in that suit was, well, that engine does not go with that aircraft. The FAA registration site shows a different engine. The court's deck action then determines that the bill of sale on which a declaration was sought that Anala owned the engine did not, in fact, convey the engine. The aircraft contract at issue essentially has two parts. One part is there was a payment of $381,000 by Anala, and it receives A, B, C, E, and through that, then apparently the determination of that 381 did not convey the engine. The second and distinct part of that contract is quoted that we have on the screen in paragraph 3, that if additional amounts basically are paid at any point in time, and as you see, the numbers go down, and then after the 12 months, it's a very small amount. Why the parties necessarily have this provision and amounts going down, but what that paragraph references and states is that Convergence will repair and make good the aircraft to an airworthy condition with a certificate of airworthiness, et cetera, et cetera. A whole different issue than did Anala then purchase and obtain the engine. The claim then, Anala decided to then propose and offer the $15,000, which again is a totally separate and distinct claim than this bill of sale gives them title.
But could it have been brought in the previous suit?
It could have been brought if in fact Anala had paid the $15,000 or made the decision at that point to pay the $15,000. In part, the issue at that point was the engine, and if it got title to the engine, it didn't want to pay any more money for what paragraph 3 provides. And the reference in the response to the hearing previously, we did file a motion to amend And, at least argument at that point by Mr. Palter included that, again, my recollection was the comment, this claim could be brought in a separate suit, but arguably the claim had not yet arisen and could arise, and they could decide at a later time, okay, we want to pay the $15,000 and we get something entirely different than title to the engine. We get convergence, repairing and making good to the aircraft to an airworthy condition. So entirely different, different rights, additional monies paid, et cetera. In some ways you could say it was two different contracts, but our initial one was that the engine is here in Carrollton being repaired, and we had our bill of sale saying, okay, we think that entitles us to the title to the engine, and that first suit said no. Second suit is upon the payment of $15,000, we want convergence to repair and make good to aircraft, airworthy condition, et cetera, pursuant to that provision. So we think based upon that, these are distinct and separate claims that in this point.
I guess one of the things that kind of concerns me a little bit is, the Supreme Court, as you said, takes a kind of a transactional approach to this. You're saying that in the previous suit, you took the position that it should be added to the previous suit. Did I deny the motion for leave, or what happened there?
Specifically, Your Honor, you did not grant his motion for leave. It was filed within 7 days of trial, and it was denied after the deadline for filing. So the filing had expired. The case was set within 30 days before trial, and therefore he had sought to seek leave to include an additional claim for breach of contract, which, by the way, specifically Convergence had filed a counterclaim on the contract itself, the purchase and sale agreement. So the court did not grant leave. It considered the four corners of the purchase agreement as to the issue of whether or not this contract conveyed the engine. It arises out of the same facts as to whether or not there was any breach of that contract. And what is not disputed by the parties is that the remaining parts, that is the airframe, all of the other avionics, all of those are in their possession.
Can I ask a quick question? Because I want to, I'm kind of trying to think through the procedural history of the previous case. And so, as I understand it, then this request to add this additional claim that we're basically litigating now was made within 7 days, I guess, of trial, is what you're saying, correct?
Correct.
And he sought a motion for leave, and I guess I denied it. Our operation of law, it was denied. Are there any cases that talk about the transactional approach to res judicata that talk about a situation where in the previous case they tried to bring the claim and they couldn't because of some procedural issue, like it was filed late or whatever? Has that come up in any other cases?
Well, the court has considered the issue of whether or not it is a compulsory counterclaim or not. Our position is this certainly should have been pled as a compulsory counterclaim.
Right. I get that argument. What I'm asking is, are there any appellate court cases, preferably at the Dallas Court of Appeals or Supreme Court, or just in Texas, that have addressed the issue of, okay, in the previous suit, they tried to bring in a claim, it was barred because of, whatever procedural issue, they were untimely or whatever. And should that be res judicata when it was never actually litigated, but it could have been litigated? That's what I'm trying to get at. Is there any cases like that?
I haven't found any specific cases. The applicable rule is 97A, and we can provide additional briefing to provide this court authority that on appeal, there's no doubt that this either was or should have been a compulsory counterclaim because there was a filing seeking to add it. The fact that it was not timely pled effectively means it is now barred. It's like any other compulsory
I
counterclaim.
understand that's what you're saying, and I'm not disagreeing with you necessarily. I would just like some authority on that point, you know.
We would be more than happy to provide a supplemental brief on that issue to your honor as its consideration, as well as a proposed order on this motion.
I think that makes sense. Mr. Hayes, is there anything else you wanted to say?
No, I can also look at the authority on that issue. I guess my final point is, while cases talk about the transactional analysis under this contract, then Anala still had the ability to act on a provision that was separate and distinct from what is being determined or being viewed in this lawsuit. And there's not a limitation on time saying it has to be, they then have to make that decision on this other issue.
Let me ask this, Mr. Hayes. Why was this filed so close to trial? And let me just ask this, because this would be important to my analysis. To me, I guess it would be at least relevant, maybe not dispositive, that if, say, for example, this issue did not arise until after the pleading deadline. For example, there was no way that you could have known about the existence of this claim until after the pleading deadline. It would seem to be kind of manifestly unfair to say, look, you're going to be barred from bringing it even though you were past the pleading deadline when it arose. But when did this claim arise? Did it arise before the pleading deadline or after the pleading deadline?
I would view it as arising when the client then seeks to enforce this provision by making a decision that it's going to pay $15,000 to pursue the other remedies under the contract. So certainly, Judge, it's not something that arose 2 years later because some event, but the contract, again, doesn't set a time period on this particular provision, which we contend is, has separate and distinct, I guess, remedies, rights, obligations than the remainder of the contract, and the issue on does the bill of sale convey the engine.
Remind me again, in the first suit, I decided this on summary judgment within 7 days of trial. Is that right? Or
it was not within 7 days of trial. It was within 30 days of trial, but the pleading deadline had elapsed in it, and he filed his amended pleading within 7 days of the motion for summary judgment. Within 7 days.
Within the motion of summary judgment hearing.
Correct. That's correct.
I think that the motion for leave was filed, I think, 7 days before. So, but agree that the trial date was coming up soon.
And that there's no question that the scope of the application at that time, which is I want to include a breach of contract claim, included the very same facts that he's seeking today. And that there's no question that that choice, that is, did they tender, have they ever tendered any monies? The answer then was no. The answer today is no. They clearly could have brought this claim on day one. There is no condition precedent that hadn't been satisfied. They were aware of all of the facts, and they were aware that we had filed a counterclaim specifically on this purchase and sale agreement. So therefore, to say that somehow this did not accrue until subsequent to the dismissal of the case simply isn't true.
Okay.
Okay, I guess the final words by me, that the deck action was as to the engine. The defendant's then response related to, well, this agreement on its face doesn't convey the engine. What we're seeking here is entirely separate provision that if we pay $15,000, get these other rights and remedies. That, again, no limitation in the contract when that money is to be paid. Yeah, certainly we're aware of the contract at the time of filing the first suit, but at that point we were not proceeding on any contract claim, which required us to pay money then to get convergence to take an action.
And lastly, Your Honor, I don't disagree with what Mr. Hayes' comments were. However, because Convergence had then filed a counterclaim specifically on the purchase and sale agreement, that gave duty for him to file any compulsory counterclaims arising out of the same transaction. And this clearly arises out of the same transaction, which is why it's barred today. This is basically a collateral attack on this court's prior judgment.
Okay. You know what the briefing I want is. When you submit the briefing, each of you submit a proposed order as well on it. Try to get that email. How long do you think that would take you to do?
Get that to you, close of business tomorrow?
Sure.
Does that work for both of you? Okay.
Yes.
Get it to me by the close of business tomorrow. Make sure that you e-file it and also email it to my court coordinator and ask her to email it to me.
Will do.
Okay,
Thank you, Your
guys.
Honor.
Thank you, Your Honor.
Interesting issues, and hope you guys have a good day and you be safe. Okay.
Thank you.
Thank
Have
you.
a good morning.
Thank you.
I'm trying to leave.
That's all right.
Okay.
Good to see you, Mr. Hayes.
I'll just turn my machine off. I can't get off. So, all right. Good afternoon. Good morning.
Okay, who do we have here? There's somebody here that their iPhone. Who is iPhone?
Good morning, Your Honor. Haley Jones. For whatever reason this morning, I'm listed as iPhone. I'm here for the 10 a.m. status conference on Stickle versus Cypress Bank. I represent the defendant, Cypress Bank.
Okay, is your opposing counsel here?
I don't see her here yet.
Yes,
Oh,
Your
there she is.
Honor.
Okay.
Kimberly Wallace here for Mr. Stickle.
Okay, great. So this is a scheduling conference, is that correct?
Correct.
So the main issue we have here is just when do you want to set this for trial?
I would like to look at a September date, Your Honor.
Judge, you're still on YouTube. Just sorry to interrupt.
It's okay.
Oh, okay.
This is a hearing, so it's okay to be on YouTube. But thank you for letting me know. So this is a scheduling conference. We're just trying to figure out when you'd like to go ahead and set this for trial.
Your Honor, a September date is fine with the defendant. I think, Your Honor, I think we were recommended to set it on a Tuesday.
So is this, I'm sorry, I kind of lost my train of thought. So is this a jury or a non-jury case, or do you guys decided?
A non-jury.
Non-jury, okay. So let me kind of talk to you kind of big picture about the docket, which is we're trying as many non-jury cases as we possibly can right now. We're not able to try any jury cases due to the pandemic and other issues. And so, so I guess my concern is if we move into September and you want to be non-jury, and this is not dispositive, I'm not saying I won't put it in September, but I guess we do have one non-jury week in September that we could potentially set it in, but you might want to try to set it earlier if you can to increase your chances that we'll actually go to trial, because once we start trying jury cases, it's going to be very hard to try any non-jury cases because they always get precedent to jury cases over non-jury cases. And so, you know, the pandemic seems to be getting better pretty quickly from what I'm reading. Will we be doing jury trials by the summer? Possibly. I don't know. You know, there's a lot of ifs out there. You might want to set this sooner, but if you don't feel like you can get it ready sooner, I do have 1 week, September 21st, that is a non-jury week that I could potentially, that would be the one real date in the second half of the year that I could try it. I would encourage you, if you can get it ready in time, to maybe set it in June or July. But if you can't, we'll be glad to set it that week in September. What is y'all's preference?
I could do, I mean, if you had something mid-August, that's probably the earliest I think we could do it.
Well, Your Honor, I have a 2-week jury trial beginning on August 16th. It's going to, between the pretrial prep and the the trial itself, August is going to be difficult for me.
Could you guys do July?
Let's see.
I just don't know what you still have to do in the case. I'm not trying to,
Yeah.
I'm just trying to maximize your chances of actually going. So.
Sure, Your Honor. I mean, frankly, there's a lot to do in the case because we've worked to try to get it resolved instead of actively litigating it. And I still think that there's a reasonable chance that happens.
Me too.
So July 20th that week, July 27th, both are clear for the defendant.
I could do that the July 27th week.
I'll just make sure it's
That's.
Yeah, I mean, it's possible with the way things are going that we could be back to jury trials by July 27th, but I think it's still more likely than not that we're not going to be. But I'm happy to reset you to July 27th if you'd like. It's totally up to y'all. So that's at the date kind of when you want to try it.
I think that's the earliest we could possibly be ready, Your Honor, if we don't get this resolved. And again, I think we will, but I think July 27th is probably the earliest we could get the depositions and things taken that we need to take if we are going to try this.
Let me just check one thing, July 27th. Okay, yeah. All right, that's, I guess, and what I would, something to kind of put in the back of your mind, if we get to July 27th and we're doing jury trials, you're probably going to get bumped. And you could request, you might want to request that September 21st date. That is basically my only non-jury week of the second half of the year. So something to kind of think about in the future. So anything else we need to chat about? Do you want to go ahead and put together an agreed scheduling order on that too?
Yes, I can do that, Your Honor.
Okay. Can you grab Rhonda for me? Okay. All right, guys, will you be safe? And we'll go ahead and reset this and just get us an agreed scheduling order at your convenience, okay?
Okay.
We'll do that. Thank you, Judge.
Thank you. Goodbye. Bye, Haley.
Bye-bye.
Bye.
So on this case here, the Stickle versus Cypress case, we've set it for trial on the non-jury docket for July 27th. All right, is everyone here on the Moss versus Marco Princip case?
I am present, Your Honor.
Your Honor, Marco Princip. It looks like did Google or something, they cancel it? Because on the docket it says canceled by attorney.
I don't know, did they?
I think they did. That's what it says.
I don't know. It's very possible. I have the written docket in front of me. Let me look up the other. If they did,
About this because we didn't get a notice to show cause by Mr. Meldau because we just got.
Yeah, it looks like it's not on the docket anymore, so it must have been canceled. I'm not sure why, but it's not on the docket.
Judge, Gene DeBose is representing Holly Moss. An agreed order has been filed by Google and the plaintiffs, which takes them off of the two orders which they were disputing, which are the turnover order of September and the temporary injunction order. I have questioned them.
Give me 1 second. I'm sorry. Let me look that up.
It was filed Friday.
Oh, 9:30. So I may not even have it yet. So let me take a look. What you said on Friday?
Yes.
Motion to reconsider.
My recollection is it was fairly late on Friday, but.
So many things filed in this case. I don't, let me share screen and you can tell me which document you think it might be.
It was filed at 9:21 p.m. on Friday.
Do you see it here on the screen?
No.
All right, there's so much going on in this case. Let me look at this. So, yeah, go ahead and email the order because we don't have it. So there's a couple other, there was the hearing set at 10, which is a motion reconsider. That's apparently been canceled, I guess. And then there's another hearing at 3, I guess, on a show cause order. Is that right?
I'd like to address that with the court if I could.
No, it's not set right now, so we're not going to address it. And then there's also a hearing in regards to which accounts will be garnished, set by defendant Brian Martin. Is that set? That was set for 9 today, maybe, or no?
That was canceled by the administrator, I believe.
She never talked to me about it. Rhonda, can you grab Rhonda for me? I'm sorry. So Rhonda, there's a note on here that there was a hearing in regard to which accounts will be garnished set by Brian Martin. It was supposed to be at 9 o'clock today, and they said you canceled it. That's a different thing. Can you check it out? Yeah, because I'm not aware of, I wasn't aware of this hearing, and so I don't know why it would be canceled. She said there might have been an email, but she's going to look. Okay, so we have a hearing at 3 o'clock on the motion to show cause.
I was going to ask you, we just got the order to show cause, and so there's a problem with getting notice out to the alleged contemnor. So I was going to ask, in an effort to help you with, to make your docket, use your time efficiently, I was going to ask you to, at 3, to call the matter and then continue it so that we don't have to have additional orders to show cause presented to you.
Okay,
and
that makes sense.
Yes, sir. We just got the order today, and that's all I wanted to mention to you so you could free up your time later today I'm sure you have other matters you could.
So what's this issue with the garnishment? Do you know? Has there been a motion? I haven't seen is there a motion on this garnishment issue?
No, sir, not that I know of.
Mr. DuBose?
I'm unaware of the whole thing.
Okay. All right. So I guess we will see you guys at 3 o'clock then. Is that right?
Yes, Your Honor.
Okay.
One brief comment on the proposed order. The way it reads is that Google is no longer subject to either the turnover order or the order that was issued in November, Google only. And my question to the parties that have proposed that is, does that mean that my client's channels are going and their income are going to be returned to her, for which I haven't got an answer? So I'll probably have an objection to the entry of that order. I have substantial issues about my client's channels. since her third-party rights were apparently determined in the turnover order ex parte, which is improper. You can't do third-party rights without a hearing. As to the injunction, she had no notice of the hearing on the injunction. Frankly, I don't know if she had it. She would have known what to do with it. But so her interests were not represented when Your Honor determined that it is her husband who owns those channels and not her. And I have a motion on
Mr.
that.
DeBose, I have no question that you're correct that we need to determine. I mean, the fundamental issue, I think, at least that I'm aware of, in this case, is who owns those channels. And I agree with you. That needs to be litigated. That issue needs to be litigated.
Okay. Well, and I've got a motion on that for reconsideration set 2 weeks from today.
That's fine.
But that's my only concern that I mentioned here as to whatever settlement Google and the plaintiffs have made. I'd sort of like to know what the terms are, but maybe they'll tell me.
Honor.
Yes.
First off, Ms. Holly Bone Martin has always been emailed pursuant to the court's order on alternative service. And she was also served with notice not only of the TRO, but also notice for the temporary injunction hearing, if you will. And she has always been served in accordance with the court's order on alternative service, which includes email. So she's had notice, if you will, of all of these matters. All these hearings that involve any aspect of this matter, because she is a party, if you will. That's one. Those affidavits are on file by the process server with return of service affidavits, if that makes sense. Two, the problem is, Mr. DuBose, we were due discovery from Google, if you will, in early February, before we actually mediated with Judge Jordan. That was the purpose of getting this from Google regarding some of the ownership issues of these 7 channels that are involved.
Let me just say this. I don't feel terribly comfortable even having any type of substantive arguments on this because this hearing was canceled and Google's not present. And so to the extent you want to argue about what Google believes or didn't do right or did do right, we don't have a hearing set for right now. So
that's not my comment.
So we can talk about this at 3 o'clock when we have a hearing properly set, or at least arguably properly set. But right now, having these arguments without Google present, I don't feel terribly comfortable with because the hearing.
These comments are directed solely to Mr. DuBose and his client.
I don't care. I'd rather have everybody present and knowledgeable about this. So
he filed a motion
to end the hearing, and we'll see you guys back at 3 o'clock. Okay.
Thank you.
Thank you, Judge.
Yes. Okay, let me